What's up to all you dads out there and everybody that's supporting the Daddy Loves You podcast? Thank you for being there for us. Daddy Loves You podcast is for advocacy of fathers' rights and for also equal shared parenting. We are trying to change the laws in all the states, and we are also providing a platform for people to tell their story. Please join us. Please share. Please comment. Please spread the word, and please subscribe. So this is going to be the second episode of Basic 50 States. We're going to go over Illinois, Alabama, and Ohio. And if it's the first time you're listening in, Basic 50 States is basically going over a slight or minimal overview of the laws for parental rights in each of these states. This stuff is highly researched and it should be quite accurate. We need to make sure that we are informing each other and ourselves of what we can do in our states. You need to be able to discuss these things with your lawyers, or if you're trying to defend yourself for your children in court, please have this as an overview as a beginning of what you are doing. I am in no way a lawyer, and this is just going to be general advice from a fellow father, okay? So we're going to start off with Illinois. And so in Illinois, the laws pertaining to parental custody establish a framework for determining the allocation of parental responsibilities, categorizing them into decision-making responsibilities, which is legal custody, and parenting time, visitation. In cases of mutual agreement, parents submit a joint proposed parenting plan for court approval. Disagreements trigger mandatory mediation, with a certified mediator assisting in reaching a consensus. If mediation fails, a judge determines parental responsibilities based on the child's best interest. You all suggest you try and work this out together as parents. That's always going to be best for your kids. It's the right thing to do either way. You shouldn't even have to be going to court unless there's some kind of physical violence that has happened. Again, I've stated in my last episode, no will in all of them, there are no parental alienation laws in the United States. It's something that we're working on changing because it's quite obvious that it happens a lot. And it shouldn't be left up to the opinion of the judge. There should be laws written on these things. So regardless of the relationship with the co-parent, legal guidance is advisable. Qualified child custody lawyer can navigate the process based on individual goals and circumstances. Frequently asked questions about Illinois custody laws are addressed below to provide a foundational understanding before proceeding with a child custody case. Custody without a court order. In absence of a court order, both parents have equal rights to the child in Illinois. Parenting plan outlining custody and responsibility must be created. If no agreement is reached, either parent can file a petition for the court to establish custody and visitation rights. As much as I hate to say it, if you do make a parenting plan on your own, try and get a legal mediator to agree to it so both of y'all can sign on it, or at least have a notary there when you sign so it can be it can have legal standing in court, because both parents these days seem to want to use things against each other. I'm not going to say it's more men than women and more women than men, but we know what the truth is. So, child custody and divorce. During divorce proceedings, child custody is determined based on the child's best interests. Factors considered include parents' wishes, child's preferences, prior custody arrangements, and the child's adjustment to home, school, and community. Unmarried mothers initially have sole custody, while unmarried fathers must establish paternity. This can be achieved through marriage at conception, signing the birth certificate, or filing a paternity action. Once paternity is established, custody can be pursued in the case of married parents. Fact that I'm going to continue to tell you all, 40% of DNA testing proves that the child is not yours. That is a real statistic. Okay, most of the time people don't reveal these secrets until their deathbed, or they want to use something against you or something like that. Don't depend on the birth certificate. Please take a paternity test. Court decisions prioritize the best interests of the child, considering parents' wishes, child's preferences, mental and physical health of all parties, and other relevant factors. A detailed list of factors can be found in the Illinois Marriage and Dissolution of Marriage Act. Both mothers and fathers have equal legal custody rights, with no legal presumption favoring either parent. Unmarried fathers do need to establish paternity. I'm repeating that. Parenting time in Illinois encompasses physical custody and visitation rights. The court considers the child's best interests in determining parenting time, often following the model parenting time schedule, but allowing flexibility for the child's well-being. There's no specific age determining when a child can choose a custodial parent in Illinois. The court may consider the child's wishes, but it's not the sole determining factor. The primary residential parent has physical custody most of the time and makes day-to-day decisions. This parent may have advantages in decision-making authority, but typically needs to collaborate with the other parent. Joint custody in Illinois involves shared decision-making responsibilities. Legal custody is now termed parenting responsibilities, encompassing significant life decisions. Parenting time refers to physical custody, with equal schedules encouraged for cooperative parents. Parenting plans in joint custody are specifying decision-making authority and detailed parenting time. A well-structured plan fosters communication and stability for the child. I suggest that you all go to co-parenting therapy. At least read some of the same books together. I have quite a few books that I've read that are great. Co-Parenting Handbook, Magic 123, and quite a few others. Eventually I'm going to make an episode where I list these out for you all to take on and read. That it will be coming in the future. So, joint custody schedules, or as they called it a moment ago, the model parenting time schedule in Illinois. Common schedules include alternating weeks, 2 weeks each, midweek overnights, 2-2-3, 2-2-5-5, and these are days, 3-3-4-4, every other weekend, and a 60-40 plan. This is crazy. There's so many different things, okay? It's very hard to navigate and understand what's best for the child, and it's giving the judge just their own opinion on whatever they want to do. So it's in the best interest of both parents and of the kids to figure this out on your own. Child support is impacted by parenting time, but is not automatically eliminated in joint custody. Support is determined based on each parent's income, financial resources, and the child's need. Parents can seek modifications based on the significant schedule changes or evolving child's needs, but generally after the plan is at least 2 years old. So you have to establish that your all's plan is working well before you can establish a change, and that's both parents. So unmarried parents have the same rights and obligations as married parents, but paternity is not automatically recognized. Paternity must be established for fathers to enjoy equal rights. This keeps coming up over and over again. Take DNA. If you're afraid that the children are not yours, if you're going to lose them and you don't want to go through this, you can do this at home when you have your kids. It is not illegal for you to do a home test. Okay? You can swab yourself, you can swab your children. Usually these tests cost about $99. You can order them online and they can come to you. It's a lot cheaper than doing it in court. Now, if you figure out that they're not yours and however that wants to go, you can present your findings in court, but they will do their own DNA testing. Unwed fathers can establish paternity through marriage at conception by signing the birth certificate or filing a paternity action, often involving genetic testing. Registration with the putative father registry is recommended. Excuse me. After 2016, the term custody was replaced with parenting time and parenting responsibilities. Unmarried parents have the same rights, focusing on decision-making authority in physical custody. Some of this stuff is going to be repetitive, guys, and it's on purpose. You need to hear these things. Decision-making responsibilities are allocated based on the child's best interests, considering various factors listed in the laws. You can find these laws yourself on your government's websites. Unmarried parents follow the same child support calculation as married parents, considering income, parenting time, and the child's needs. Almost every state has its own calculation sheet, and you can find that on the government's website. A lot of these government websites are full of all kinds of jargon, and their search templates are absolutely horrendous. It's taken me hours and hours and hours and hours just to find these laws and accumulate them into something that you can understand. So you can go out and find that. They are constantly changing. Kentucky, where I'm from, they just changed this year for the better, it seems, from what I've learned recently. So in summary, for Illinois, custody laws are designed to prioritize the child's best interest, providing a framework for parental responsibilities and parenting time. Whether married or unmarried, legal guidance is crucial to navigate the complexities of child custody cases. There is no such thing in the United States that I have discovered so far as a public defender for family law. It just doesn't happen. Even in the states that take a percentage of the child support you pay, which this should be allotted to a public defender for men and women, they don't do it. I don't know why. I'm told it's just too expensive because of the criminal stuff they have public defenders, but I believe, if we started nipping this in the butt with the children, our crimes would go down. As we know, the national statistics show that fatherless homes create a whole lot of the crime that we have. They create a lot of the suicide we have. They create a lot of the homeless that we have. They create a lot of the prison fulfillment that we have. Okay? It is, in my opinion, if you can get the money, get a lawyer. If you cannot, we are working towards developing a fund that's called Daddies Need Lawyers, and we will be taking donations. Once we are monetized, I will be using money that I get to be able to help people out, okay? Please look forward to that. Keep your eye out. Keep listening, because I will be announcing it when it happens, because it will be happening, everybody. I'm not stopping. So next we're going to move on to Alabama. Okay? So state policy for child custody and visitation in Alabama. Alabama advocates for joint custody post-marriage dissolution. That's divorce. Promoting regular contact between children and parents, acting in their best interests. That's from the Code of Alabama, Title 30, Chapter 211. Some of these things I'll be able to put in what the codes are so you all can read them on your own. I can't do it for all of them. It's very difficult. Eventually I'll be much better at this, and we will redo these episodes. So in Alabama, the types of custody there are is sole legal custody and joint physical custody. With the former giving one parent decision-making authority and sole residency, the latter shares equal legal rights and responsibilities, though not necessarily equal physical custody. That's the same thing, Title 30, Chapter 2 through 11. Considerations for custody awards. Custody decisions consider factors such as child safety, age, parental cooperation, provision, and the child's preferences. Exceptions include a presumption against custody for those with a history of violence. That's going to be in every state. If you are beating your man, if you are beating your woman, that is going to change things for you, as it should. Because that's a terrible thing. No one needs to be doing that shit, especially with your kids involved. Okay? So that's Title 30. It's chapters 3:1 to 3 to 200. You can look all that up. There's a lot of extra stuff that goes along with those. I suggest you read into those. Visitation rights are flexible, guided by cooperation and parenting agreements. In disagreements, intervention programs will be mandated. Grandparents and other access visitation. Grandparents have legal rights in Alabama and can seek visitation aligning with the child's best interests. Considering factors like parental status, abandonment, or marital dissolution. So basically that means that, say we have a violent offender, and we'll go ahead and assume it's a man. The grandparents or the parents of the man, the grandparents of the child, can still lobby for access to that child. And I suggest you all do it. If grandparents are listening, you will never be a replacement for their father, but they need to be in touch with that side of their family, at least the bare minimum. Collaborative post-divorce agreements stress flexibility, dedication, and respect between parents. Now, you can do this without going to court. It can get messy. You need a mediator. I suggest going to court in the state for this stuff. Because, again, there's no father's rights. Okay, so post-custody decisions, a court order is binding. Non-compliance may lead to court intervention, modifications, or penalties. If you can settle this stuff out of court, I would still bring it in front of a judge to say, yes, this is legally binding. You don't want to go to court later and say, look, we made this agreement and it doesn't mean anything in Alabama, really. Pretty scary. So Alabama addresses parental relocation, presuming distant moves aren't in the child's best interest. Non-custodial parents can object, triggering a court hearing. There's not really anything that has to do with distance in Alabama for this. Just within within the state itself, is still considered to be in best interest of the child. But anything out of state can cause the state themselves to step in, for you to not necessarily have to file. You can just kind of bring it forward. You don't need a lawyer for that. But if someone is trying to take your child far away from you and you are not willing to move to be with that child, then you need to get a lawyer and you need to file a motion. Financial child support, responsibility, and emancipation. Financial child support continues post-divorce until the child is emancipated, usually around 18 or high school graduation. That's every state that I've reviewed so far. Support factors include the child's needs, parental income, health, and impact on maintaining two households, aiming for self-efficiency and pre-divorce lifestyle maintenance. Guys, in every state that I've seen, this goes towards the woman, okay? You could be making less, the woman could be making more, you're going to pay child support. That does not equal out the households. What they're saying here does not actually happen in court, ever. And these laws need to be changed, and they're working on being changed. I'm currently talking to litigators, and I will be going to a convention soon, and people that are standing up for this already. Okay, they're trying to change this federally, which would mean that it enacts over all 50 states. Alabama bases child support on combined net income, using official guidelines. Court order payments follow a prescribed formula. Alabama Rules of Judicial Administration, Rule number 32. That's how you're going to be able to look that up and see what your income sheet will be, your support sheet. That's going to tell you how to fill everything out. It's kind of confusing, but you can find information online that's going to tell you how to do that properly. When the court decides, parents can reach agreements on financial child support. Parenting agreement addressing unique circumstances is beneficial. Now, child support is calculated considering gross incomes, pre-existing obligations, children count, and health care coverage for that parent. Not necessarily just those children, but that parent can have other children with other people, and those children are also considered into the big picture. The court says they ensure fair distribution based on the child's interest. I don't think that's true, and I think anybody that's going through it can say that as well. Recalculation upon request is possible, requiring a substantial change in circumstances. Factors include parental incomes, new responsibilities, and other health conditions. This is all also under Code of Alabama, Title 30, Chapters 3.1 through 200, Alabama Rules of Judicial Administration, Rules 32 and 35. You all need to hire a lawyer if you can. Every time. If you can get a lawyer, please get a lawyer. This stuff is hard to do on your own. I've seen courts throw people out and say that they don't care if the law says that you can do this on your own. They will tell you, go get a lawyer. So if you can, rally together. Start a GoFundMe. Ask family members. Go out on the streets and ask for money if you have to be able to get a retainer for a lawyer. And be on the lookout for daddies need lawyers in the future. Next, we're moving on to Ohio. In Ohio, the official terminology for child custody has evolved into the allocation of parental rights and responsibility, and visitation is now termed parenting time. However, informally, the conventional expressions of custody and visitation continue to be used. So that basically means that they've changed the verbiage in the laws, but when you go to court, the judge is going to use the same old verbiage because they don't care what the laws are, because this stuff is all based on what the judge's opinions are. Okay? Almost every state is like that. They're going to say, well, here's what the law is, but this is how I feel we need to do because I have the right to change this pertaining to this specific situation. Should parents find themselves unable to reach a consensus, the court intervenes, addressing both matters through a trial. It's noteworthy that procedures may exhibit slight variations among different counties and judges. Development of a co-parenting schedule needs to happen. Formulate an effective co-parenting schedule, draft a professional parenting plan, and maintain records of the actual parenting plan. A lot of states want you to put all this stuff in a book, and everybody only seems to put negative stuff in the book. But you need to track every little thing in this state. Ohio is different than a lot of other states in almost all their laws. There's an old saying that says, the way Ohio goes is the way that the country will go. That's changed a little bit more recently, but for a lot of things it's still the same. So you need to track exact times of when your child's being picked up, dropped off, if they're sick, what medications you've given them, if there's injuries when they're with you from regular play. I would even go down to the fact of using the bathroom. Write all that stuff down because the more detailed you can be, the better. You also need to write down things like good positive events in your child's life. Make sure you track medications that are given. And when the parent is that's on the opposite side does good things, track that too. Make a good book, people. Nobody needs a book of negativity because that only hoards negativity and that creates negativity. Let's give the parent the benefit of a doubt that they're also a good person, and you need to be able to highlight that. Now, a good friend of mine, he keeps all this stuff journaled, and he writes down things and events and his thoughts and everything every day, and eventually plans to give them to his kid. And I just think that's amazing. That is a lot of work, and it is very hard to keep up with. But if you can do it, your child will thank you when they get older, for sure. So in Ohio encompasses two pertinent courts, juvenile and domestic relations. In smaller counties, both functions might be consolidated within a common plea court, while larger counties maintain separate locations. Married parents present cases to the domestic relations court, while unmarried parents handle custody or paternity matters in juvenile court. Again, Ohio is different. They do things weird. It could be beneficial. I'm not exactly sure. I've not dived that far into it. I would love somebody that's up there to contact me so we can talk about these things further. Even a lawyer, that would be fantastic. So the varieties of custody in Ohio: court orders on parental rights and responsibilities delineate residential and legal custody. Unmarried parents typically confer sole custody to the mother until paternity confirmation. That is DNA, not a birth certificate. You could be there when that child is born. You can sign that birth certificate. That does not mean that's your kid, okay? Residential custody concerns the residence of the children and their overseeing guardian. Sole residential custody designates one parent as a primary giver. Joint residential custody entails nearly equal time with both parents, necessitating a parenting time schedule for shared custody. Legal custody involves decision-making authority on critical matters like education and medical care. Sole legal custody vests decision-making rights in one parent. Joint legal custody facilitates collaborative decision-making per the parenting plan. Shared parenting is where both parents assume legal and residential custody, with one designated as the residential parent for school enrollment. Typically granted when parents reach a settlement. Litigating parents secure shared parenting if they cooperate and live in proximity. That means close to each other. Factors influencing custody decisions prioritize the best interest of the children. Factors include parental caregiving ability, cooperation willingness, and a history of crime, violence, or substance abuse. Consideration of a child's age, preferences if mature, and relationships also guide decisions. I'm not sure what age they consider mature in Ohio. In Kentucky it's 14. Once a child reaches 14, they can decide which parent that they want to live with. I think that's pretty awesome. I think that it could even be considered to be lower than that. Duration of custody proceedings. Timelines fluctuate based on court, judicial schedules, issues at hand, and the need for evaluations. Juvenile court cases may conclude within weeks. The complexity or special circumstances can extend the process. Divorce cases can often span months, with shared parenting agreements gaining finality post-divorce. So costs hinge on case duration, professionals involved, in geographical location. Trial expenses can be substantial, with custody cases potentially reaching $10,000 and divorces up to $30,000. Additional fees may include guardian ad litem or forensic evaluator services. Guardian ad litem is basically the state's representative for your child. They go in between the parents and say, look, I've taken a vested interest in this child. That's presented by the court. That's who appoints this person, and says that I'm going to help you make what decision is best for the children, not just what the parents say is best for the children. Low-income litigants may qualify for reduced legal fee representation. That's awesome. So you can find a lawyer that will take a lower amount. And to be honest, that doesn't mean that the lawyer is not going to be as good. This person might just be giving. Sometimes it can even become pro bono, which is pretty awesome for Ohio, but extremely rare. So when it comes to self-representation, while it's possible, self-representation is discouraged, as in all other states. Pro se litigants must adhere to legal norms, just like a lawyer. Self-representation is more prevalent in juvenile court due to its simpler proceedings. So there's confidentiality protocols in Ohio. Court hearings are typically public, with occasional exclusions for security or protective reasons. Certain records, like forensic evaluations, may be restricted. Victims of domestic violence can request confidentiality regarding their address and identifying information. So basically that means that you go to court, and usually there's a whole lot of people in court. Even when you have hearings, there's going to be other people that are waiting for their hearing time, usually, because the courts are so congested that they have to have these people in there, because it's got to go back to back really quick. So these things like pictures of child abuse or, abuse between the parents can be approached to the bench. So to view these things, you'll have to go up to where the judge is. They won't show it on a big screen. They won't talk about it and stuff if you request it. In Kentucky, they call that sealed court. That is a thing. So our Ohio Parental Rights and Responsibilities, detailed information is available in Chapter 3109 in the Ohio Revised Code. Chapter 3109 of the Ohio Revised Code. So you'll get a little deeper into this on your own. Organizational imperatives. The custody determination process demands meticulous organization. Tasks include formulating a parenting plan, drafting schedules, time tracking, and expense management. I have terrible experience with this. I don't like doing it, and for years I haven't done it, and here recently I have to start doing it. My opinion is that it doesn't do anything good for the kids. It only gives the parents reasons to go back in front of court and say, he didn't do this, or she didn't do that, or this or that, and blah, blah, blah. It fuels the fire instead of saying, well, it was great, the parent did this, it was great, the parent did that. Approaching parental rights and responsibilities process necessitates careful consideration, potential legal counsel, and the maintenance of organized documentation throughout the proceedings in all circumstances in all states. If you all can get a lawyer, get a lawyer. Don't try to do this on your own. If you cannot, you can try to do this on your own. I have to wrap this up by saying that I am not a legal representative. These are not my opinions. A little bit of it that I throw in and out, or it's my opinion, as you can tell. But most of the things that I'm presenting you with are the laws for these states. That does not mean that this is the way that it's going to go for you, but it is going to give you a general knowledge for you to be able to speak about these things. And every single parent needs to stand up and learn about these things. Don't depend on a lawyer to do it. Even if you have the money, just throw in the money at them and say, okay, you do whatever you're going to do. Don't do that, okay? Never do that. Please. Show the care for your children by learning these laws on your own. Being able to have the discussion with your lawyer. Don't let your lawyer just be all willy-nilly. Your lawyer provides a service for you. Okay? You pay them. They don't control you. You control what they do. Okay? Too many people throw money at lawyers and just say, do whatever you're going to do. I don't care. That's a bad idea, people. Okay? Another thing that I would like to add in that's going to help a lot of people out, feel a little bit better when you're in court, and I'm going to put this in on all these episodes from now on. If a lawyer has to go to defamation of character, if they have to say that you were this person or you were that person, it's, subjugation, that is a personal opinion, that you are a deadbeat person, or you're this kind of father or this kind of mother, or your job isn't as important as another person's, or anything like that, that case is weak. Facts are what rules the court. Okay? Yes, to a certain amount, it becomes a show, and people can sway judges by saying these things. It shouldn't be that way, but it does happen. But when it comes down to, if you have the cold hard facts lined out and you have everything showing that you have done everything you're supposed to do, otherwise known as due diligence, then it should take, or be warranted by the court. It should take precedent by the court. Okay. I'm going to end this again by saying, I'm not a lawyer. You cannot hold me liable for these things. And I appreciate everybody that's come out and watched this episode. As I go into these things, I'll get better and better and better at these Thank you for your all's grace in allowing me to be able to do this. And please like, follow, and continue to join the conversation. Please come online and be part of my podcast. Tell your story. There are millions of you out there, men and women, that are going through absolutely terrible times with their children in custody in these states. Please reach out to me. Please come on my platform. Please vent. It will help you so much. Otherwise, please listen to all the episodes, and hopefully you find something that will help you out. Thank you again. This is Daddy Loves You, the podcast from Millstone Productions. Good night.